Welcome to Got Invention Radio. I'm your host, Brian Freed, and tonight we have Beth Hutchins. She's an intellectual property attorney licensed in Arizona, and she's very active with helping inventors and different businesses with their intellectual property. Beth, welcome to the show.
Thank you, Brian. I'm glad to be there.
How you doing tonight? Happy New Year.
You too, my friend. How are you?
2013.
I know. Can you believe it?
And it's just begun. So, Beth, there's inventors out there. I always say this at different levels of their invention process. There's entrepreneurs that are listening that are trying to secure their intellectual property. They came up with a great business name. They're doing things on the internet, and there should be some sort of protection. And there's even people that are writing recipe books or writing a book, just different types of intellectual property all around with building a business, working on inventions, and so forth. So we need your help. All different levels listening. All different levels listening tonight. Let's start off with the basics first. But before we go there, why don't you tell us a little bit about yourself, Beth?
Well, I am a solo practitioner in Phoenix, Arizona, and I started out as a patent attorney and then expanded my practice into all other areas of intellectual property. I do trademarks, I do copyrights, and with the internet becoming more and more relevant in terms of e-commerce and marketing and just in business in general, it's kind of expanded into that area as well. And I'm finding that intellectual property in general kind of lends itself nicely to internet law. I also do a little bit of First Amendment defamation and that kind of thing. And those are the primary areas of my practice.
Okay. And this is something that you do all day long, and what's a typical day for you there? Are you working with one-on-one, business, commercial type of environment?
Oh, it really depends. I have clients that are single, small-time artists or single photographers or that kind of thing, up to very large multinational corporations. And I also help other lawyers. Intellectual property is starting to bleed into everything now. And so I'm finding that some lawyers will need help. They'll have, for example, a probate matter, and it'll have an intellectual property issue. So I provide that kind of guidance as well. So, yeah.
Oh, that's excellent. Beth, tell me what the differences are. We've had different patent attorneys on our show and patent search experts on our show and just all different types of intellectual property types on our show. But there still seems to be some confusion, and I always like to keep it fresh. Tell us, and if you don't mind, I'd like to focus. I know patents we've spoken about. Trademarks and copyrights we kind of always skim over. And if you don't mind, I'd like to kind of focus a little bit more on those on this show, as well as internet law, which covers people securing a domain name thinking that a domain name is copyright, and copyright protection, and also the content that you include in your instructions manual for your invention, your website content, whatever it is. You want to be able to try to secure what's yours and what you think may be yours. So can you give us some definitions just to start off with of what these are, and then we'll start getting a little deeper with them, okay?
Sure, you bet. And I think, to start, especially with my inventors and my entrepreneurs, there's a tendency to focus on patents as the end-all be-all of the IP world, and I've seen many inventors get really discouraged when they get a search that says, their dog washing machine is as old as the hills, or there's just very narrow in scope, and they just kind of throw their hands up and say, okay, well, that was a bust, and nothing could be further from the truth. To start with our patents, as a refresher course, you have your utility patent, and that protects your inventions, your new, useful, non-obvious features. They're good for 20 years. And then also, which will play into our copyright discussion, is a design patent. And those will protect your ornamental features of your particular invention. They're typically cheaper and easier to get than your utility patent, and they can be a really good tool if your inventive concept isn't quite enough to justify the expense and the time for a utility patent. And incidentally, I also consider design patents in tandem with my copyright analysis because sometimes they can be very similar. And so those are our patents. And then
what about
for our trademark,
provisional? I'm sorry. What
Go
about
ahead.
a provisional? I always like to touch on that because some people think a provisional patent is a full patent.
Oh no, it's not a provisional. I consider those more of a place saver. They do have their useful tools. They're good for a year, and they're a way for you to kind of get your place in line, get yourself a filing date, and you can also kind of fine-tune the final parts of your invention before you actually marry yourself to a utility patent. They can be quite useful if you're worried about any kind of statutory bar or that kind of issue coming up with filing a patent.
Okay, so patents are for something that you can see, feel, taste, smell, that type of experience. Is that?
Sure. It's any inventive concept. Anything that, we use those words over and over again, new, useful, and non-obvious. And so it can be an improvement to some existing technology, or it can be a completely new technology. It could be a widget. It could be software. It can be chemical. It can be a plant. It can be all sorts of things, so long as there's some sort of new and usefulness of this item. And it may be easier to contrast them with trademarks and copyrights as we get further into the discussion.
Okay.
But when you're thinking of a patent, it's your thing. It's what you invented as opposed to a brand name or an artistic concept, if that kind of helps to clarify it.
Sure. And what covers that side of it, as you just mentioned, the artistic side?
That would be a copyright. Copyright protects your creative expression or your creative spark. That's your art. That's the written word, music, movies, sculpture, painting, photography, those types of things. That would be your copyright protections. And one thing that's very common in my inventors is there's a tendency for people to blur all three areas. They will think that they should get a copyright on their invention or a trademark on their book, and they're three separate and distinct bodies of law, and they operate very, very, very differently from each other.
Okay.
So that's just something to bear in mind when you're thinking of the broad scope of intellectual property. They're all under that umbrella, but they're very, very, very different.
Okay. Well, we touched on two of three. So tell us what trademarks cover.
Trademark is your brand name. In the trade, pun intended, of course, we use the term source identifier. And what that means is that a person will see your particular trademark and automatically think of your company as the one that's selling that good, right? So, for example, when I say Coca-Cola, everybody listening automatically thinks of a particular company's cola-flavored soft drink. That's a source indicator. I just say a word, and you automatically think of a particular company.
Well, it's a company. It doesn't necessarily have to be the soda, because when you said Coca-Cola, I think about shirts, keychains, magnets, right?
That's a that's a licensing issue, and that's kind of beyond the scope of what we're doing here. But for the most part, when you think of trademark as a synonym for brand name. Okay. So we say Coca-Cola brand soft drink, Starbucks brand coffee, McDonald's brand fast food, those types of things. And we use the term source indicator because unlike patents and copyrights, which are tied up in the United States Constitution, trademarks are tied up more in fair trade and consumer protection laws. And so what we have is there's a need for the general public to be able to recognize something, and that's our standard with trademarks.
Okay.
Is what does the public think when they hear of this particular word or they see this particular logo? When you see the Nike swoosh, you think of a sporting goods company, or the Golden Arches, and you know without even seeing McDonald's that you can go into that restaurant and get a hamburger.
Okay, so this is where it could be confusing for some. When you mentioned the trademark, that you said that the logo, a logo is art, and that also fell under copyright. So and also mottos, right? Just different sayings that companies may have. Maybe you could just clear that up for us.
You bet. And it gets a little strange because in trademark, and I'm going to keep using this word source indicator, so long as a particular thing does function as a source indicator, meaning when a person sees that and thinks of a company, it can be a trademark. So there are instances of smells being trademarks, sounds. I've even read things of like texture can be a trademark. So long as you encounter that particular stimulus, whatever it is, and think of a company, then it can be a trademark. But usually when we speak in trademarks, the most common ones would be a word or a slogan or a or even like a design. And so when we have McDonald's, we have one trademark called McDonald's, which is just the word. And then we will have, the golden arches, which is their little logo. But they also have those slogans, I'm loving it, and that type of thing. And those can all be trademarks because when you see McDonald's, you know hamburger. When you see golden arches without McDonald's written underneath it, you think hamburger. And also when you hear that ba-da-ba-ba-ba, you know that is a jingle for a hamburger restaurant. Does that make sense? Does that
sure
clear
does.
it up?
But let me ask you a question, Beth. Let's say
Sure.
I come up with this fantastic computer and I started this company and I want to call it McDonald's Computers.
I would
do I have
strongly
the right to do
discourage
that?
that.
But do I have the right to do that?
It's kind of a sliding scale, and here's why. Because trademarks are as weak or as strong as how popular they are. So McDonald's, if I say McDonald's, that is a very strong mark. It's got recognition worldwide. So anybody, when you think of McDonald's, they think of a hamburger restaurant. Would it be impossible? No, but if you were my client and you said, I've got this great computer and I want to call it McDonald's, it would inspire a conversation of there are better marks for you to choose that could represent your computer that don't have anything to do with McDonald's. Number one, if you want to try and get it past, the trademark office, they may take issue with that. They may not. It would depend. It's a completely different class of goods, so that is arguably something that could go in your favor. But then also you have a very, very, very famous mark that could operate as kind of a limitation on you being able to use it.
And that's actually
and that's
where
one of them. Go ahead.
Yep, that's where I was kind of leaning towards is to maybe have you speak a little bit more about class of goods, because I do
Sure.
see different companies with the same names, but they are in the different what's called class of goods, and they have the right to use a trademark and use it in commerce.
Sure. And the reason for that is because all of trademark law really kind of depends on what's known as consumer confusion. And what that means is that because trademarks tied up in fair trade and consumer protection laws, we want to make sure that your customers and your competitors' customers and everybody else in the computer selling world is not going to be confused as to who's providing what. And so it's very subjective. It's a sliding scale, and I hate to do that lawyer thing where I say, well, it depends, but it really does depend. So when you see a mark, for example, we have McDonald's, which is a very famous mark on hamburgers. Could you put it on computers? Perhaps. But it's also, if you have something that's not as famous as McDonald's, Joe Schmo's Computer Company, and then you've got Joe Schmo's Computer Company, and then you've got Joe Schmo's Florist, the consumers aren't really going to be confused because neither mark is terribly famous either way, so we're not concerned that somebody is going to somehow think that one company had decided to start selling that other company's goods, or if they were actually the same company. Does that make sense?
It sure does. Thank you for that.
Okay.
Now let's stick to the basics just for a few more minutes here. So I'm an inventor. I have a product. You mentioned to me about patents. So when I look to get started with getting a patent, getting some sort of protection on my invention product, or maybe it's a new chemical perfume or something that somebody came up with, or just something like that, what do we do first? What's your suggestion, Beth?
Well, number one, it's going to depend on your budget. Especially my